Hearing in the appeal, Harpur Trust against Brazel.
Yes, Mr. Glidden.
May it please your Lordship, may it please your Ladyships. I appear for the Harpur Trust along with my learned friend Mr. Roberts, who sits next to me, and Miss Meenan, who sits behind me. The claimant, Mrs. Brazel, who sits behind my learned friends, continues to be a long-serving and valued employee of the Harpur Trust, and she is represented by my learned friend Mr. Gullick, to my left, Mr. Wilson, who is observing from home and with coronavirus, and to whom we wish our best, and Miss Webber, who sits behind Mr. Gullick. Unison, the intervener, is represented by my learned friend Mr. Ford, and behind him Mr. Purchase. I should say, before outlining the issues in the appeal, that it is the first time that Mr. Gullick and Mr. Purchase have appeared as senior counsel with letters patent which aren't PDF. And it's particularly, and we offer our congratulations to them, and it should be right that their first appearance in silk is in this court. My lords, my ladies, the issue in this case is whether the duration of leave under the working time regulations conforms to the duration of work. Does the duration of leave under the working time regulations conform to the duration of work? Or are workers entitled, as the claimant says, to 5.6 weeks of pay regardless of their working pattern or how many weeks of a year that they work? The single ground of appeal is that under the working time regulations, we say a worker's right to paid annual leave is accumulated to the amount of their work. We make good that ground of appeal in 3 submissions. Firstly, we say the Working Time Directive expresses the EU legal principle that leave conforms to work. It is the purpose of EU paid annual leave that it should provide leave from work and relaxation. Accordingly, the duration of leave should conform to the duration of work. And we put forward this single proposition. A week's leave is the average amount of work done in a week over the leave year. A week's leave is the average amount of work done in a week over the leave year. Secondly, we say that principle of leave conforming to work from EU law has been transposed into domestic law by the working time regulations. Thirdly, and finally, we set out how the conforming principle applies to domestic law. It boils down to a simple proposition. For irregular hours workers, such as Mrs. Brazel, her work is irregular across a differing number of weeks and differing hours. Her entitlement, and those of other workers with no normal hours, is to paid annual leave of 12.07% of the hours for which they are paid. Mrs. Brazel is the paradigm irregular hours worker. She is part year and 0 hours working. She works for part of the year and irregularly across that. It is her case that engages the first principles in calculating work and pay, and that can be calculated by one of 3 methods which we explore later. Before I move to those 3 submissions, I need to say what this appeal is about and what it is not about. Firstly, this appeal is about calculating the amount of leave that some workers receive. It is not about the rate of pay during that leave. It is about the amount of leave. The 12.07% applies to the number of hours leave. It is not a rate of pay. Secondly, when I mentioned irregular hours or workers with no normal hours, the workers in scope of this appeal are irregularly working workers. Those like Mrs. Brazel who have no normal hours, they are normally hourly paid workers, often 0 hours workers. This appeal is not about where a worker receives a salary throughout the year in equal instalments, such as the teachers to whom the claimant unsuccessfully tried to compare herself. Those employees, the working time regulations are simple. They take 5.6 weeks of leave during that salaried time. This appeal is about those with no normal hours. Can I take the court, please, briefly to the facts of the case? And if I can see the court is, all the court is using electronic bundles, I'll just give page numbers rather than dividers.
Yes, please do.
Page 236. Page 236 at paragraph 4. The basis upon which the claimant's first claim was put was to acknowledge that holiday pay was paid by the Harpur Trust in 3 instalments in December, April and August. And a couple of lines down, it, that is the Harpur Trust, calculates the claimant's holiday pay by paying 12.07% of the hours accrued over the term as holiday pay at the end of the term. If I can ask you please to turn to page 242, you'll see some relevant contractual terms. Clause 17 of particular importance, working hours. As a visiting teacher, requirements for your services will depend upon a varying level of demand for individual personal tuition in your subject instrument. Demand may vary from term to term. There are no minimum hours of work guaranteed to you, and you have no normal hours of work. It's a...
Sorry, could you just repeat that page reference?
I beg your pardon, page 242, my lady.
Thank you.
And it's clause 17 of page 242 under working hours. And simply, demand may vary from term to term. There are no minimum hours of work guaranteed to you, and you have no normal hours of work. It's a 0 hours contract. The rate of pay at clause 22 is hourly. And the entitlement, the contractual entitlement at clause 27 runs from September to the end of August. And Mrs. Brazel will be entitled to 5.6 weeks of paid holiday. Can I ask you to turn to page 248? At page 248, it was Mrs. Brazel's case that she was under an obligation to do work in holidays. The tribunal made express findings on it at paragraph 49 of page 248. So page 248, paragraph 49. The claimant gave evidence that she had to attend to emails from parents and or the school, and there was an expectation that she would deal with these in the holiday period. That was not made out, however, as it appeared there was no such expectation in the school holiday period, and that it was the claimant's choice to respond to emails during that time. So the claimant was under no obligation outside of the school term. Over the page, at page 249, you see that the Harpur Trust submissions were based on the ACAS guidance which was then in force. And the ACAS guidance that you can see is summarised by the tribunal there, but appears, if I can ask you please to turn to page 276, and you can see that the ACAS, which is the non-departmental public body with statutory function to promote the improvement of industrial relations, sets out its guidance for holidays and holiday pay. And this guidance was dated at least sometime after November 14, as one can see at page 276, because it refers to the Bear Scotland case that was heard on the 4th of November. And if I can ask you please to turn to page 283.
I'm afraid to say my screen is completely frozen and I'm having difficulty moving the documents, turning the pages. Ah, that's worked. Good. Thank you.
You all right?
I hope it's all right. Thank you.
Thank you.
I'll speak again.
Thank you. So 283.
283. Lady, I know that's why I don't use electronic, because I live in fear of it failing on me in front of this court. So, but in any event, at 283.
We're almost completely electronic now. That's a byproduct of the pandemic.
My Lord, I feel chided, and I shall endeavour to be better in the future.
I'm not chiding you. The risk you mention it can be a real one.
I'm grateful.
I must say I've heard many explanations why council don't use electronics, but I'd not heard that one before.
It's, fear is the key, my lord. Page 283. What leave do casual workers get? The guidance sets out. If a member of staff works on a casual basis or very irregular hours, it is often easiest to calculate holiday entitlement that accrues as hours are worked. The holiday entitlement of 5.6 weeks is equivalent to 12.07% of hours worked over the year. And the calculation for 12.07% is set out. And for those of a mathematical bent, it's quite simply this. You take 5.6 weeks of leave, therefore you subtract that period of leave from the full year, 52, to get to 46.4. You divide that leave, 5.6, to the proportion of the full working year, 46.4, and that gives you 12.07%. And that proportionately gives every worker the same amount of leave as a worker working the full year.
I'm very sorry, I cannot both use my laptop and the screen. I think there's something wrong technologically. I'm really sorry.
Shall we adjourn for
just a
5 minutes to see if IT can
Thank you.
resolve this matter? I'm very sorry, Mr. Glynn, but Lady Arden's difficulty needs to be addressed. The court will now adjourn. Well, it looks as if, Mr. Glynn, your caution has been demonstrated as being wise.
Entirely my fault. I do apologise to everybody.
Milady, we're on page 283.
Yes, I got that. Thank you.
And I've just read out the part of what leave do casual workers get, and it's the equivalent of 12.07% of hours, and I'd explain the calculation at the bottom of page 283. And you can see across the page.
So then you get that hourly figure, and then you multiply that by her hourly rate.
Precisely.
How it works. Yeah.
Lady, yes, and you see that at the top of page 284, in fact, ACAS gives an easy example of that. So if someone works 10 hours, they are entitled to 72.6 minutes of paid holiday, and that is 12.07% times 10, that's the 10 hours. That gives 1.21 hours, and that equates to 72.63 minutes.
Just looking at page 242, do you say that's how an employee signing a contract of employment should have read clause 27?
My Lord, this appeal is purely on the statutory, both at the EAT and at the Court of Appeal. It's only the statutory entitlement that is to be considered. The contractual entitlements, the appellant accepted, were dealt with properly by the tribunal. So whilst the contractual entitlement is set out at clause 17, the contractual issue is not before the court. What is before the court is the interpretation of the working time regulations, the statutory entitlement.
Well.
And based on the Employment Tribunal found that, and there's no appeal from it, found that the 5.6 weeks could be read pro rata, as it were, to the hours on the 12.07%. But there's no appeal against that finding. And my Lord, you may question me about it, but it's not an issue before the court.
Thank you.
At page 284, the advice goes on. There's no specific calculation for working out the holiday entitlement for term time workers. You may find it useful to look at the calculations used for annualised hours. Now, for someone like Mrs. Brazel, there's no calculation at the beginning of the year as to what the annualised hours are. However, by the end of the year, you know what all the annualised hours are, and you can apply the 12.07% to those hours, or use, as ACAS says, all the casual irregular hours. And that's the casual irregular hours example that I've used or taken the court through. Now, that was ACAS guidance, was effectively used was effectively used by tens of thousands of employers, applying it to millions of employees and workers from when the regulations came into force in October 1998 till a period shortly after the decision of the Employment Appeals Tribunal on the 6th of March 2018, allowing the appeal in this case against the Employment Tribunal's decision. Now, my learned friends will take you to many criticisms of what I say. They say it's unworkable. They say it's too complex. They say it's impossible for both workers and for employers to understand where they are. However, the proof of our case that it is workable, it's easily understood, is the fact all we are advocating is the old ACAS guidance that was used without trouble by hundreds of thousands of HR departments and understood by millions of workers. Now, the proofs you have seen in the annex are complex. But when it comes down to it, when it comes down to the 12.07% of hours, that is simple and it can be easily understood as it was for some 20 years. Can I then take you, please, to the law and particularly to page 604. Divided 6, page 604. And at page 604, you see the Working Time Directive. It's a consolidated directive, 2003/88, and it consolidates but says the same thing as the former directive, 93/104. And the parts of the Working Time Directive I wish to take you to, please, are Recital 2, the second half of Recital 2. Directives adopted on the basis of that article, that is Article 137, or was Article 137 of the treaty, are to avoid imposing administrative, financial and legal constraints in a way which hold back the creation and development of small and medium-sized undertakings. That's balanced, of course, by Recital 4. The improvement of workers' safety, hygiene and health at work is an objective which should not be subordinated to purely economic considerations. And finally and importantly is Recital 5. All workers should have adequate rest periods. The concept of rest must be expressed in units of time, i.e. in days, hours, and/or fractions thereof. Community workers must be granted minimum daily, weekly, and in this case, that we're considering as annual leave, annual periods of rest and adequate breaks. If I can ask you to turn to page 606, you'll see the Article 7 right. Page 606, Article 7.1, Member States shall take the measures necessary to ensure that every worker, it's a universal right, not to some workers, but every worker, is entitled to paid annual leave of at least 4 weeks. So paid, and then annual leave of at least 4 weeks, in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and/or practice. And then Article 7, paragraph 2 does something different. It provides that the minimum period of paid annual leave may not be replaced by an allowance. You simply can't just pay annual leave when employed. The only time one can do that is on termination. So if a worker's employment is terminated and they haven't taken all the leave due to them, they receive a payment for the untaken annual leave. Over the page, Article 15, I beg your pardon, more favourable provisions. This directive shall not affect Member States' right to apply or introduce laws, regulations or administrative provisions more favourable to the protection of the safety and health of workers or to facilitate or permit the application of collective agreements or agreements concluded between the two sides of industry which are more favourable to the protection of the safety and health of workers. So the Article 15 allows Member States to gold plate the directive rights. It allows the Member States to pass more favourable provisions. Then if I can turn you please to page 575, behind divider 5, page 575, we turn to the working time regulations. And you can see on the front of the page that the working time regulations are made under section 2.2 of the ECA 1972 in relation to measures relating to the organisation of working time. Obviously, the Directive on the Organisation of Working Time, these regulations are designed to transpose the obligations imposed by the directive. The fact that these 1998 regulations predate the directive I've taken to you to, which is 2003, it is of no import because, as I said, the Directive 93/104 was consolidated by 2003/88, but no material changes were made. If one turns over the page to page 576, there's interpretation and definitions. And the seventh definition one can see is day, which means a period of 24 hours beginning at midnight. However, there's no definition of weeks or 4 weeks or 4 weeks of annual leave. But there is Regulation 2, paragraph 2, which is at page 578, 3/4 of the way down. In the absence of a definition in these regulations, words and expressions used in particular provisions, which are also used in corresponding provisions of the Working Time Directive, have the same meaning as they have in those corresponding provisions. So where there's an absence of a definition and the provision is corresponding to the directive provision, it has the same meaning as in the corresponding provision as in the directive. Now, Article 7.1 provides a right to paid annual leave of at least 4 weeks. That right is bifurcated by the working time regulations. You find the entitlement part, the 4 weeks part, in Regulation 13, and you find the rate of pay part in Regulation 16. So at Regulation 13.1 on page 579, subject to paragraph 5, a worker is entitled to 4 weeks annual leave in each leave year. And you'll see that that is just a bold statement, as is in the Working Time Directive, of annual leave of at least 4 weeks. But the language is strikingly similar. In the directive, it's annual leave of at least 4 weeks. In the regulations, it's 4 weeks annual leave. And they're clearly corresponding provisions. One turns over the page, please, to page 581. One sees Regulation 13A. Regulation 13A was introduced by the government under the Working Time Regulations 2007. It was part of its manifesto promise that the 8 days of bank holidays in the United Kingdom wouldn't be used, as some employers were using them, to use up, as it were, the 4 weeks of annual leave. And so what they did is they added the period of bank holidays. And the language is clear at 13A. It's entitlement to additional annual leave. That's, of course, additional to the annual leave at Regulation 13. And then at paragraph 1, a worker is entitled in each leave year to a period of additional leave, again additional to 13.1, determined in accordance with paragraph 2. And for our purposes, paragraph 2E is the relevant paragraph because it's after 2009, and it adds 1.6 weeks to paragraph 13. And again, it's important, it's using the same language of weeks that Regulation 13 uses. Regulation 13 uses 4 weeks of annual leave, and this, again, is using the word weeks. If one then turns to Regulation 13A, paragraph 3, the aggregate entitlement provided for in paragraph 2 and Regulation 13.1, so it's adding what's in Regulation 13.1 to Regulation 13.2e, is subject to a maximum of 28 days. And it's obviously adding the same thing. So it's subject to a maximum of 28 days, which means, my lords, my ladies, when I said that a week is not defined in the regulations, a week of leave cannot be in these regulations for a full year worker 6 or 7 days. And it can't be because obviously 5.6 weeks of 6-day weeks would be 33.6 days. 5.6 times 6 is 33.6. So that would be in excess of the aggregate of the maximum of 28 days. And equally, 5.6 times 7 would be in excess. But 5.6 for a full leave year worker, 5.6 times 5 days is 28 days. At page 583, you have Regulation 14.
Is there another provision that deals with how much leave you have to have, or how much break you have to have during the week?
Yes, there's daily. So one could work, one needs a weekly rest, which is a period of 24 hours every week. One needs a full period of weekly rest of 24 hours, so the maximum one could work is 6 days a week under the WTR. And you need each day 11 hours of rest. So, my lady, you're absolutely right to suggest that a 7-day week through the year isn't possible under the WTR. But a 6-day week would be. Regulation 14, you see compensation related to entitlement to leave. And this is the transposition of the Article 7.2 right, that is the pay in lieu, and that is under Regulation 14.1, a worker's employment is terminated during the course of his leave year, and on the date of the termination takes effect, the proportion he has taken of leave differs from the proportion of leave that has expired. And then a calculation, A times B minus C, is taken. It looks complicated, but it's relatively simple. A is the entitlement under Regulations 13 and 13A. You multiply that entitlement by the proportion of the year that's gone by, and you take away from that any annual leave that's been taken up until the date of termination, and it leaves you with a figure. And under Regulation 4, that figure might be a minus figure, and depending on a relevant agreement, which means a contract, that might include the worker having to pay back a sum. But in most cases, it's the employer paying the worker a further sum. At page 586, you see Regulation 15A. And Regulation 15A was enacted by the British government after a challenge by BEC2. When the working time regulations were first passed, they provided for a 13-week qualification period before any entitlement to annual leave arose. And the Court of Justice held that that was precluded by Article 7. It was a day one right for every worker. And therefore, the government introduced Regulation 15A to prevent abuse by workers in the first year of taking all their leave, as it were, and then leaving during the first year. And what you have at 15.1 is during the first year of his employment, the amount of leave a worker may take at any time in exercise of his entitlement under Regulation 13 or 13A. So like Regulation 14, it's entirely parasitic on the entitlements under Regulation 13 or 13A, is limited to the amount which is deemed to have accrued. So it's a deeming provision, and the relevant deeming provision is paragraph 2A, because it's not an Agricultural Wages Scotland Act. And for the purpose of paragraph 1, leave is deemed to accrue over the course of the worker's first year of employment at the rate of 1/12 of the amount specified in Regulation 13.1 and Regulation 13A2. And simply that's just to limit the worker from taking too much leave. And finally, in respect to the working time regulations, is Regulation 16 on page 587. And this is payment in respect of leave. And as I showed you, the working time regulations bifurcated the entitlement and the rate of pay. And it provides a worker is entitled to be paid in respect of any period of annual leave to which he is entitled under Regulation 13 and 13A. So again, parasitic on the entitlements, at the rate of a week's pay. The rate of a week's pay is set out in paragraph 2. Sections 221 to 224 of the 1996 Act shall act for the purpose of determining the amount of a week's pay for the purposes of this regulation, subject to modifications. And there are certain modifications, such as the disapplication of certain sections. However, it's important to look at what Regulation 16 then does. Regulation 16 then applies the rate of a week's pay to each week of leave. Each week of leave is an entitlement provision that refers back to Regulation 13 and 13A. If I can then take you to section 224 at page 490. Page 490. And this is the relevant section for this irregular hours workers with no normal working hours. This section applies where there are no normal working hours for the employee. It's extended to workers by the working time regulations. The amount of a week's pay is the amount of the employee's average weekly remuneration in the period of 12 weeks ending, and by reason of amendments made by Regulation 16, with the first day of leave. So the calculation date is the first day of the leave taken. And then under Regulation, paragraph 3, I beg your pardon, in arriving at the average weekly remuneration, no account shall be taken in which no remuneration was payable. So if one has weeks in which, for instance, taking the case of Mrs. Brazel, she doesn't work because she's on holiday with no obligation to work, you take back the 12 weeks to the next date of term under this calculation. And it's right to say that from the 6th of April 2020, the Employment Particulars and Paid Annual Leave Regulations, the Employment Rights Regulations 2018, amended the reference period of 12 weeks to 52 weeks. This case was determined under the 12 weeks, but the rate of pay went back to 52 weeks. Now, our appeal is about entitlement. It's about each week of annual leave. It's about the amount of leave to which a worker is entitled. And finally, under this legal section, can I take you please to the supplementary at page 497. And at page 497 under section 229, which is in the same chapter as section 224, where under this chapter account is to be taken of remuneration or other payments for a period which does not coincide with the periods for which the remuneration or other payments are calculated, the remuneration or other payments shall be apportioned in such manner as may be just.
Sorry, what page was that?
Page 497, my lady, at section 229, subsection 2. Page 497, where under this chapter account is to be taken of remuneration or other payments for a period which does not coincide with the periods for which remuneration or other payments are calculated, the remuneration or other payments shall be apportioned in such manner as may be just. And that's a wide power which is granted under section 229, subsection 2. Before I go to my first submission, there are some propositions which it would be useful simply to take the court briefly to in the case for the appellant, please, which you'll find at page 80. I beg your pardon, page 79.
So 2292 is dealing with where someone is actually paid on a monthly basis, but you have to calculate it for a week's pay, so you apportion the monthly salary to a week. Is that?
Well, lady, yes, or it could be.
Is that dealing with where they get a bonus in one? So if in one of those weeks, one of those 12 preceding weeks, they got a bonus which related to the whole 6 months' work, then you take a proportion of that.
Yes, and equally, for instance, if one didn't get the bonus in those 12 weeks but was paid outside of those 12 weeks, one might include it. Yes. If I can take you, please, then to page 79 of the bundle. And these propositions are taken from, and apart from the final proposition, you'll see them repeated, or indeed, including the final proposition, you'll see them all repeated in the way of the courts of justice as they, as it were, do accretion. They state principles again and again and again, as I'll show you. But it's useful just to take these propositions quickly at this stage. At page 79, the right of paid annual leave is a particularly important principle of EU law from which there can be no derogation. It cannot be interpreted restrictively. And we agree, and we submit all these proposals, or all these propositions, are entirely on foot with what our appeal is about and what it seeks to do. Member States are not precluded from introducing provisions that are more favourable to workers than under the Working Time Directive. See at page 80, At page 80, the worker must receive his normal remuneration in respect of annual leave, the purpose of which is to put him in a position regarding pay which is comparable to periods of work. D, the right to paid leave is one right. It is one coin with two sides. One side is the right to leave from work, and the other is the right to pay during that leave from work. And finally, the purpose of the right to paid annual leave is to enable the worker to rest from carrying out work which the worker is required to do and to enjoy a period of leisure. So the purpose is to enable the worker to rest from carrying out work. To those 5 propositions, I'd add one that appears in Learned Friends for the intervener's skeleton, which can be found at page 168, paragraph 18. Page 168, paragraph 18. However, in relation to one aspect of Article 7, the European Court of Justice has been prescriptive. It has said the system of rolled-up holiday pay, by which workers are paid a supplement to their pay as representing holiday pay, is incompatible with Article 7. We agree. Rather, workers must be provided with a payment in respect of a specified period during which they take leave. And it's our submission of the conforming principle, which tackles the abuse of rolled-up holiday pay with irregular houred workers, which tackles that head-on. And you need to be able to know how much leave each worker is entitled to in order to grant that worker leave to ensure that one's not merely granting rolled-up holiday pay. So, moving on then to the meat of my first submission, and that is the period of annual leave conforms to the work done. It's reciprocal. Can I take the court, firstly, please, to page 857, which is behind tab.
You needn't worry about tabs.
I beg your pardon. I thought it was a courtesy to my then friends who are...
yes.
No, I beg your pardon, my lord. Yes, of course.
Not at all. If your colleagues are working from paper, then it's quite proper to refer to tabs. 857.
857. And here we have the case of Greenfield, which is a domestic UK case, and that's important. And over at page 859, the context of this case involves both paragraph 3 and 4. It involves both the Framework Agreement on Part-Time Work, so the Part-Time Workers Directive, and paragraphs 5 through to 8, the Working Time Directive. So it's the context we accept of both part-time workers and also the Working Time Directive. And at page 861, at paragraph 14, Mrs. Greenfield left the Care Bureau on the 28th of May 2013. It's not disputed that she took 7 days of paid leave during the final leave year. Mrs. Greenfield took, at paragraph 15, Mrs. Greenfield took those 7 days of paid leave in July 2012, and during the 12-week period immediately preceding that holiday, her work pattern was 1 day per week. So at the time she took those 7 days, she was working 1 day per week. From August 2012, Mrs. Greenfield began working a pattern of 12 days on and 2 days off, taken as alternate weekends. So here you're going from someone doing 1 day a week to 6 days, or sometimes 7 days a week if she was using an alternate weekend, which is the other method by which weekly rest can be given under the regulations. And what was said by the Care Bureau is halfway down, 4 lines up from the bottom of paragraph 17, I beg your pardon. Since Mrs. Greenfield had taken her leave at a time when her work pattern was 1 day per week, she had taken the equivalent of 7 weeks of paid leave, and accordingly, she had exhausted her entitlement to paid annual leave. We say that result would be the result of the Court of Appeals analysis. That result would be the result of the result that my learned friends for the intervener and the claimant urge upon you. At page 862 at paragraph 22, Mrs. Greenfield argued that national law, read in conjunction with EU law, requires that leave already accrued and taken should be retroactively recalculated and adjusted following an increase in working hours, for example, following a move from part-time to full-time work, so as to be proportional to the new number of working hours and not the number of hours worked at the time leave was taken. Just pausing there, this isn't a problem of only part-time workers. This is a problem of irregular hours workers. People who work in hundreds of industries that you'll be aware of, who work some weeks for 1 or 2 hours, some weeks not at all, and some weeks for 30, 40, 50 hours. They are in the same position as Mrs. Greenfield. Their work flows up and it flows down. And the problem with the Court of Appeals analysis is you simply take the snapshot when they take the leave, and that gives an entitlement which runs out. The Court of Justice, at page 863, enunciates three of the principles I've taken you to at paragraphs 26, 27, 28. And it's almost like a Greek chorus that you'll see again and again in the cases as to the importance of the right, that it can't be interpreted restrictively, and it's to every worker. And based on that, it then says at paragraph 29, furthermore, and here is the heart of the conformity principle, furthermore, it is not disputed that the purpose of the entitlement to paid annual leave is to enable the worker to rest from carrying out the work he is required to do under his contract of employment. So the reason why you're granted paid annual leave is because you're working and you need rest from that work. Consequently, the result of that is the entitlement to paid annual leave accrues and must be calculated with regard to the work pattern specified in the contract. So that's the statement of the principle. What unit do we use in calculating or recalculating leave? And the Court of Justice answers that at paragraph 30. With regard in the first place to the unit of time on the basis of which the calculation must be performed, it should be noted that the unit of time used in the directive, working time directive, with respect to maximum weekly working time is the hour. And then paragraph 31, it sets out what the unit is. Moreover, as follows from recital 5 in the preamble to the Working Time Directive, the EU legislature takes the view that the concept of rest used in that directive, particularly that of annual rest, must be expressed in days, hours, and or fractions of days or hours. So the units are what you need it to be. So we have the principle, we have the unit, and then thirdly, we have the calculation. It follows that the entitlement to minimum paid annual leave within the meaning of the Working Time Directive must be calculated by reference to the days, hours, or fractions of days or hours worked and specified in the contract of employment. Now, for a 0 hours worker, you're not going to have any hours specified in the contract of employment. So you're only going to be able to make that calculation as the hours are worked. And then at paragraph 35, it follows that as regards the accrual of entitlement to paid annual leave, it's necessary to distinguish periods during which the worker worked according to different work patterns. So that's the irregular hour worker. They work according to different working patterns, and one must distinguish that, the court says. The number of units of annual leave accumulated in relation to the number of units worked to be calculated for each period separately. So you look at the entitlement on the number of hours worked, and you calculate the entitlement to leave based on the number of units worked. Now, it might be said, I carefully took you to the legal context, which is both the Part-Time Workers Directive and the Working Time Directive of this case. But in the next paragraph, the court makes it clear that this is a Working Time Directive conclusion, not one required by the Part-Time Workers Directive. So that conclusion, the conclusion at paragraph 35, is not affected by the application of the pro rata temporis principle laid down in the Part-Time Workers Directive on part-time work. So that is the principle of annual leave is a Working Time Directive principle. The unit is a Working Time Directive principle. The calculation is referred to in the Working Time Directive, and the result, that is, you must distinguish periods of work to periods of, you must conform leave to periods of work, is a result required by the Working Time Directive, not by the Part-Time Workers Directive.
But here there weren't different periods. of different working patterns for Miss Brazel. She worked the same sort of hours over the whole period that we're considering, didn't she?
Milady, no, that it was, there would be, for instance, some hours would be, it was a 0 hours, so that there might be more people doing lessons one term than another term. There might be a parents' evening one term. There might be supervision at concerts. So they were irregular hours. They weren't the same hours through the year.
Yes, but Miss Greenfield wasn't working irregular hours in that sense, was she? She was working 1 day a week for a period, and then she moved to working more days a week.
On the facts, Milady, yes, but that doesn't affect the principle that the Court of Justice is stating, is that different work patterns give rise to different entitlements under paragraph 35. And at paragraph 43, you can see that we say there are those different entitlements. At page 865, paragraph 43, in a situation such as that at issue in the main proceedings, EU law therefore requires a new calculation of rights to paid annual leave to be performed only for the period of work during which the worker increased the number of hours worked. The units of paid leave already taken during the period of part-time work, which exceeded the right to paid annual leave accumulated during that period, must be deducted from the rights newly accumulated during the period of work in which the worker increased the number of hours. And that shows that there's a continuing relationship of leave across a year. The rights accumulate over a whole year. They rise and fall. And that you can't just take leave and purely view it as irrelevant to the rest of the year. We say that's the first statement of the conformity principle, but it finds a further expression in the case of DICU at page 947. Page 947. And in DICU you have a case which is based at paragraphs 3 through to 7 on the Working Time Directive, and at paragraph 8 on the framework of parental leave agreement. So that's the legal context. And at paragraph 14, it's right that under EU law, under Romanian law, I beg your pardon, the Labour Code provided that an individual employment contract may be suspended on the initiative of the worker in the following cases: parental leave to care for a child under the age of 2. And the question that was referred is at paragraph 22 at page 949. And what had happened is Mrs. DICU had taken maternity leave followed by parental leave. Maternity leave, like sickness, is an exception to the principle of conformity under the cases, and that is entitlement to annual leave continues through maternity leave and continues through sickness. But the question that the court asked was, at paragraph 22, does Article 7 preclude a provision of national law that does not consider a period of parental leave to care for a child under the age of 2 to be a period of actual work? And what the Court of Justice does is it restates the propositions at 24, 25, and 26. But then at paragraph 27, in that regard, it's appropriate to recall the purpose of the right to paid annual leave conferred on every worker by Article 7 of the Working Time Directive is to enable the worker both to rest from carrying out the work he is required to do under his contract of employment and to enjoy a period of relaxation and leisure. And if you look at paragraph 28, is the best exposition of the conformity principle. That purpose, which distinguishes paid annual leave from other types of leave having different purposes, is based on the premise that the worker actually worked during the reference period. The objective of allowing the worker to rest presupposes that the worker has been engaged in activities which justify, for the protection of his safety and health as provided for by the Working Time Directive, his being given a period of rest, relaxation and leisure. And then the result of that principle, accordingly, entitlement to paid annual leave must in principle be determined by reference to the periods of actual work completed under the employment contract. And that's the conformity principle. And it finds expression then at paragraph 35, and it's important to note at paragraph 35, the court says, while admittedly a worker on parental leave remains during that period a worker for the purposes of EU law, so Mrs. Dickey remained a worker throughout the period, the fact nonetheless remains that whereas in the present case such a worker's employment relationship is suspended pursuing to national law, as permitted by the framework agreement, the reciprocal obligations of the employer and the worker as regards work and salary are correspondingly suspended temporarily, in particular the obligation on the latter to perform the duties required of him or her in connection with that relationship. And at paragraph 36, it follows that in a situation such as that in the main proceedings, the period of parental leave taken by the worker concerned during the reference period cannot be treated as a period of actual work for the purpose of determining that worker's entitlement to paid annual leave under the Working Time Directive. And the final case, which, although there are others in the case, the final case which I'm going to take the court to in respect of the conforming principle is to be found at page 872 in the case of Hine, and consideration starts at page 893. And at page 893, you see from paragraphs 3 through to 7, the only context of this was the Working Time Directive, although as well mention is made of the Charter, and the Charter 31.2, every worker has the right to the limitation of maximum working hours, to daily and weekly rest periods, and to an annual period of annual leave. So the Charter right, an annual period of paid leave, was referred to. And what you see in German law at paragraph 9 is, under the federal law, payment for annual leave was on the basis of, if you see the subparagraph under paragraph 9, was on the basis of the average earnings that the worker received in the last 13 weeks. So whilst the UK uses 12, German law uses 13. But further, it said after the dots, reductions in earnings occurring in the period of calculation as a result of short-time work shall not affect the calculation. So if one was put on short-time work, that didn't affect the calculation. But collective agreements may derogate from those rights. And indeed, Mr. Hine worked in the construction industry in concrete, and at clause 1.4, the collective agreement at the bottom under paragraph 11, clause 1.4, the duration of leave shall be determined by the number of days employment completed in firms in the construction industry. And that is, clause 2.2, an entitlement to 1 day of leave after every 12 days. And remuneration was provided for under clause 4, and the second paragraph of clause 4.1, the remuneration for annual leave shall amount to 14.25% of gross wage. But unlike in the federal law, there was no exception for reductions that were brought about by short-time working. And in Mr. Hine's case, as one can see from page 896, paragraph 12, page 896, paragraph 12, Mr. Hine was on short-time work for a total of 26 weeks. In 2015 and 2016, he took 30 days of leave, which had accrued in 2015. Over the page at page 20, the Labour Court of Verden, Germany, referred the following question. And the question's important because the question makes an assumption which the Court of Justice challenges. Are Article 31 of the Charter and Article 7.1 of the Working Time Directive to be interpreted as precluding national legislation under which it may be provided in collective agreements that reductions in earnings occurring in the period of calculation as a result of short-time work affect the calculation of payment for annual leave, with the result that the worker receives a lower remuneration for annual leave for the duration of the period of annual leave of at least 4 weeks? So the court assumed that although Mr. Hine was on short-time working, he was entitled to annual leave of at least 4 weeks in accordance with the directive. Sorry, the German Labour Court assumed that. At page 898, the Court of Justice again recited propositions at paragraphs 22, 23 and 24, but at 25 it reframed the question. In order to provide a useful answer to the first part of the first question, it's necessary to examine in the first place the duration of the minimum period of annual leave which is conferred by EU law in circumstances such as those of the main proceedings, and then in the second place the remuneration to which the worker is entitled to. So the Court of Justice split the question out. First the entitlement, and then second the rate of pay. Over the page at page 26, so over the page at page 899, paragraph 26 and 27, you have word for word the two paragraphs I read out to you from DICU. So 26, 27, repeat word for word the principle of conformity. And they end at paragraph 27. Accordingly, the entitlement to paid annual leave must in principle be calculated by reference to the periods of actual work completed under the employment contract. In the present case, the court went on, it's clear from the documents before the court and the observations made at the hearing that in a situation such as that of Mr. Hine in the main proceedings, during periods of short time working, the employment relationship between the employer and worker continues, but the worker does not perform actual work for the employer. And we say that's the same as Mrs. Brazel. During the holidays, she didn't have an obligation to perform actual work in the same way as Mr. Hine when he was on short time working. It follows from the case law cited at 27 above that a worker in such a position may acquire entitlement to paid annual leave to Article 7.1 of the Working Time Directive only for the periods during which he performed actual work, and thus no entitlement to leave is acquired under that provision in respect of periods of short time working during which such work has not been performed. Thus, in the present case, since in 2015 Mr. Hine did not perform actual work for 26 weeks, it is apparent in principle only 2 weeks of leave are governed by Article 7.1, but the exact duration of that period of leave is a matter for the referring court to determine. So you have the German Labour Court saying, well, can you reduce pay for these 4 weeks of leave? And the court say, well, you haven't quite got that question right. How much leave does he have? And actually on short time working, he only has 2 weeks if he's only worked for 26 weeks of the year. So we draw the following conclusions from the cases. All rest is calculated in fractions of time. All rest is calculated in fractions of time. The premise of paid annual leave is leave from work. That is what separates paid annual leave from other forms of leave. Accordingly, the entitlement to the amount of paid annual leave reflects the amount of work. Where the pattern of work changes, the entitlement must be retrospectively calculated, less the units of leave taken. The result is, as I submitted at the beginning of my submissions, the result is each week of leave is the average amount of work done over the leave year. That is the outcome of the calculation.
You don't prorate in that sense then, if there's a downwards reduction in work, do not accrue the leave entitlement on a day-to-day basis?
One could look at it accruing on a day-to-day basis. One could use that, but it's an annualised right, my lady. So whilst it may accrue as a matter of practice on a day-to-day basis, along with the ACAS guidance, that would be one way to deal with it in practice. But it is an annualised right, so it can only be properly analysed at the end of the full year.
But you could calculate it on a day-to-day basis, yes, so that the worker gets full entitlement.
Yes. And what we say is that principle of conformity has been transposed by the working time regulations into UK law. And our submissions in respect of transposition are threefold. Firstly, expressly under the regulations. Secondly, based on recognised interpretive principles of the EU, of EU law, and secondly, domestic interpretive principles. And finally, the interpretation for which the claimant and the intervener contend that weeks of leave under the working time regulations should mean something different from weeks of leave under the working time directive is unsupported. In making these submissions, we entirely agree with my learned friend Mr. Gullick that in construing legislation it should be read and given effect in a particular case according to its ordinary meaning. We entirely agree that the judiciary should not make amendments to legislation based on a preferred view of the outcome. And our submissions are based simply on the rigorous application of the clear meaning of the working time regulations. And we say from that, a week's leave is the average amount of work done in a week over the leave year, as set out in Article 7. Now, and when I say as set out in Article 7, of course, that principle isn't set out.
Sorry, say that again. The week's leave is based on...
A week's leave is the average amount of work done in a week over the leave year. A week's leave is the average amount of work done in a week over the leave year. And of course, that's not set out in terms in Article 7, but it emerges from the cases as to the interpretation of Article 7 and its purpose. And we say that's what's been transposed into UK law. And firstly, as I said, expressly, and can I take the court, please, to page 578?
Just before you go any further, could you just, the conformity principle that you keep on referring to, is that your terminology or is this a conventional terminology? And
No.
how far is it different from what has been referred to as the pro rata principle or the accrual principle, I think, in the courts below? Are we talking about one and the same? Why are you suddenly using the language of conformity?
My Lord, I think pro rata, I was nervous of using pro rata because it slightly, as one always develops one's thoughts and appeals, which I'm sorry, is I was nervous that it was only an application to full and part-time. I was concerned about that pro rata element. So, but accrual and pro rata, as long as pro rata is used in a sense of leave is prorated against work, I have no objection at all to that terminology. And indeed, in preparing my submissions, I also am going to make submissions on the conforming interpretation under Mar leasing. And I realise the conforming interpretation of the conformity principle would lead us into a semantic difficulty. But, my Lord of Boroughs, I have no objection to the prorating or accrual principles. They mean the same thing.
But it is your terminology?
Yes, it is my terminology.
Thank you.
So what you're saying is that where the working time regulations say you're entitled to 5.6 weeks annual leave a year, we must interpret that as meaning if you work full time, but that we have to cut that down, as they seem to have done in Hine, to something less than 5.6 weeks if somebody works less than full time.
Yes, and I think that's part-year work. For instance, in part-year working, one cuts it down, and one averages that over. So the proposition is that one averages that over the year, or you can, as it were, cut it down, as the tribunal did in this case.
So you cut it down to a certain number of days or hours, and then you multiply that by the hourly rate under the contract, and that's how you get her leave entitlement.
Yes.
Pay entitlement.
For the part-year worker, yes. For an irregular year worker working throughout, they may work different numbers of weeks during the year, but at the end of the week, as they accrue, you can constantly see their accrual at 12.07%, so you constantly know their entitlement. But my lady, yes, I agree with your propositions. Regulation 2, paragraph 2, to return to what I introduced in, introduced at the law at the beginning, is there's no definition of 4 weeks. There's no definition of weeks, there's no definition of annual leave. And therefore, we say, in the absence of a definition, the corresponding provision, and there's no doubt that Regulation 13 is the corresponding provision to Article 7.1, there's no doubt that the entitlement to 4 weeks annual leave should have the same meaning of annual leave of at least 4 weeks. And that meaning of a week's leave is plain and unambiguous from Regulation 2.2, and that meaning is as interpreted by the European Court of Justice in accordance with the pro rata, accrual, or conformity principle. That is, in the same way that Article 7 leave accrues or conforms to the pattern of work, so too does Regulation 13 leave conform and accrue to the pattern of work. Because there's no definition of weeks leave, there's no definition of annual leave, and it must, we say, be the same definition as the Court of Justice has shown to apply to Article 7. And we say that's not a strained construction. It's simply giving effect to Parliament's intention that in the absence of a definition in these regulations, and there is none of weeks or annual leave, that the corresponding provision in Article 7 should have that same definition in Regulation 13. And it's unsurprising that that should be the case, because Regulation 13 was directly implementing the Article 7.1 right. We simply asked this court to give effect to Parliament's express intention that the words and expressions, that is, the 4 weeks annual leave, has the same meaning in the corresponding provision of annual leave of at least 4 weeks, as explained by the Court of Justice.
So you're saying 4 still means 4, but week means something other than 5 days or 6 days?
Milady, yes. Weeks mean the entitlement, each week of leave conforms to the working pattern. It can operate in one of 2 ways, Milady, as my methods 1 and methods 2 show. So it can operate either in the Hine method, where you have 4 weeks, because Mr. Hine only works for 26 weeks, you divide the multiplier, that is 4, by 2 to give 2 weeks. Alternatively, it can operate in the Greenfield method, where you look at what a week's leave is. It's something different. So it can operate on either the 5.6, for this purposes, either it can operate on the 4, or it can operate on the weeks. That's the method which I'll come to in my third submission. So that's Regulation 13, which we say expressly adopts the meaning of Article 7.1, that is, of at least 4 weeks annual leave. And what of Regulation 13A at page 581? This is a domestic right, not implementing, obviously, the EU right. But we say that from the express language and from the legislative materials, it is obvious, we say, that Regulation 13A is adopting the meaning of weeks leave that Regulation 13 has transposed expressly. And that can be seen at Regulation 13A, entitlement to additional annual leave. And that's expressed both in the heading at 13A and at 13, paragraph 1. And a period of additional leave is obviously, we say, it's additional to Regulation 13. So we say, as a point of principle, it's obvious, isn't it, that the same denominator is being used. If there was doubt about that, we say at Regulation 13, paragraph 2E, it's using the same language of weeks. So again, it takes its meaning of weeks from Regulation 13. And finally, we say if there was any remaining doubt that Regulation 13A intended to adopt the Regulation 13 meaning of weeks, then that can be seen at paragraph 3 that the aggregate entitlement provided for in paragraph 2 in regulation 13.1 is subject to a maximum of 28 days. So what you're adding is you're adding regulation 13 to 13A leave and coming to 28 days. You can't be adding apples and pears to come to 28 days. The denominator simply and algebraically must be the same. 13A is using the same concept as regulation 13 expressly. And we say, indeed, that the propositions that not only regulation 13 but 13A adopt the EU principles can also be determined from the consultations on the introduction of the 2007 regs. And if I can ask you please to turn to page 984, page 984. This was the first consultation on the 2007 regulations. And if I can ask you please to turn to page 1004. Under paragraph 2, background, under purpose and intended effect, everyone covered by the working time regulations, whether part-time or full-time, is currently entitled to 4 weeks paid annual leave. A week's leave is equivalent to an individual's working week. And what the consultation does is it takes the easy route and it only deals with full-year workers working a certain pattern. For example, if someone works a 5-day week, he or she is entitled to 20 days leave. For a part-time member of staff working a 3-day week, the entitlement is 12 days. Now that's understood using the easy way out, but the principle equivalent to an individual's working week, what is that for a irregular working for someone with no normal hours? They don't have an easy to summarize individual's working week. What they do have is they have the average amount of work done in a week over the leave year.
But why don't they have however many hours they've worked in the previous week? Whether it's 3 days or it's 2 hours a day or 1 hour on Mondays and 3 hours on Wednesday and 2 hours on Friday. That's their working week. So they get 5.6 of those off as annual leave.
Well, not with, my lady, we say not, that doesn't understand, or with respect, we say that doesn't take into account the irregular working hours of someone with no normal hours. They don't have what your question presupposes is some kind of normal hours.
That's why you take the 12 weeks average to get you to something that is a proxy, perhaps, for their normal working.
But if one does that, then you have the Greenfield problem. And if you take the proxy, Mrs. Greenfield takes the 6 or 7 days off during the time she's working only 1 day a week, and then she works a lot afterwards, but she takes her 6 days off. She's used her 5.6 weeks.
Yes.
And that is in breach, as the Court of Justice has shown in Greenfield, that's in breach of the regulations. You need then to retrospectively recalculate. And that's all that we're saying, is that it needs to be a retrospective recalculation so that at the end of the year, a week represents the average amount of work done in a week. Otherwise, you end up with Greenfield incompatibility and Greenfield breach of the regulations. And we say that the principle equivalent to an individual's working week is absolutely right. That's absolutely right. And perhaps rightly, they've taken the easy way out to look at a 2 or 3 day week worker. But when someone's working irregular hours up and down throughout the year, the only way to do that is to work out the average work done in a week over the leave year.
But just going back to Greenfield at page 857, I've obviously misunderstood this. It says in the head note, Article 7 of Directive 2003/88 did not require a new calculation of entitlement to annual leave already accumulated to be made, where a worker increased the number of hours worked. It was open to member states to adopt provisions requiring a recalculation. As we know, they can adopt more favourable thing. But it says, in the event of an increase in the number of hours worked, EU law only required a new calculation to be made for the period during which working time had increased. So I thought that they held that there wasn't an entitlement to have the retrospective calculation.
Well, if you see, EU law only required a new calculation to be made for the period during which the working time had increased.
Yes.
Mrs. Greenfield's facts are that she had increased her working hours from 1 day per week to 12 days per week.
Yes.
So that EU law required the new calculation of Mrs. Greenfield's facts.
Yes, but what she was saying was, and she wanted that retrospectively applied to when she was only working 1 day a week, and they said, no, you're not obliged, they're not obliged to provide that. You took your 7 days leave, that was all that you were entitled to for the period you were working 1 day a week.
No, what they do, I'm sorry, no, what they do is that it can be, paragraph 43 at page 865 is actually what the Court of Justice does. So, paragraph 43, in a situation such as that at issue in the main proceedings, this is Mrs. Greenfield has taken her 7 days of leave at 1 day per week. Those are the facts of the main proceedings, with the Care Bureau saying you've exhausted it. But what EU law therefore requires is a new calculation of rates paid to paid annual leave to be performed only for the period of work during which the worker increased the number of hours worked. The units of paid annual leave already taken during the period of part-time work which exceeded the right to paid annual leave accumulated during that period must be deducted from the rights newly accumulated. And that's our case, is that what you have with a worker whose rights go up and down is you calculate them again, but you take off what's been taken as a percentage. Because she's taken...
Yes, because she'd taken 7 days.
And it's not 7, but that's not 7.
She's not entitled to 7 weeks. She's only entitled to 4 weeks. So she's had 3 extra days. So when they recalculate her leave now that she's working much longer hours, she has to deduct those extra 3 days from what her new entitlement arising from her new longer hours of work.
And her new entitlement will have given her a vastly enhanced amount of leave, so it won't anymore be the equivalent to 1 day equals 1 week. It will now be equivalent of 1 week equals 6 days. Yeah. And so you deduct that which is taken, and as I said when going through paragraph 43, is that means you can take leave. You take leave as Mrs. Greenfield does, but what the conformity principle, the pro rata principle, requires you, as the work changes, you have to recalculate that entitlement. And it may be more, it may be less.
But not retrospectively.
No, sorry, not retrospective. It's always a prospective calculation. I'm so sorry. It's always... So you can take your 7 days of leave as Mrs. Greenfield did, but because she works so much more, if she continued to work 1 day per week, that would have been all her leave. But because she's now working so much more, she's accruing far more leave because it's being accrued in proportion to her work. So she now has, rather than, she's taken 7 days leave, she now has, let's say, hypothetically, I haven't done the calculation, 14 days leave. You take the 7 days off the 14 and she's left with an extra 14 she can take because of her new working pattern.
Yes.
And that's the principle of conformity that we say the court should follow and we say has been transposed by the working time regulations. We're not asking for retrospective taking away. We're asking, we say, as I hope I made clear in the submission, is that rights rise and fall during a year, and there's a continuing relationship of leave taken under one pattern to leave taken under another pattern. And of course, we accept you have to deduct the leave taken, but the new pattern may have given you far more leave rights. If I can return to page 1004, and using Greenfield as the example, that's why we say a week's leave is equivalent to an individual's working week. And in the end, at the final analysis, that can only be calculated at the end of the year. Can I then take the court, please, to page 1011, which is the further consultation, and particularly to page 1020. And at the bottom of 1020, under paragraph 21, impact on holiday, it says that around 6 million people do not currently receive at least 5.6 weeks of holiday, pro rata for those that work part-time. We estimate that, and it's obviously baked into the working time regulations, that they should prorate, or that they prorate for someone working 1 day a week or 2 days a week throughout the year. They should also, according to the principle of conformity, accrual or pro rata, they should also prorate someone who only works part of the year, or someone who works someone works over a year depending on their hourly rate. It would be wrong purely just because, for instance, some years ago, more people worked these settled patterns, whereas we know hundreds of thousands, if not millions, are working irregular patterns now. If I can take you forwards, please, to page 1024 in this second consultation. A table showing the calculated leave entitlement at paragraph 31, a table showing the calculated leave entitlements can be found inside the back cover of this document. And that's simply showing the, as it were, the rise, and it was a gradual rise until April 2009. A week's holiday, and this is the proposition stated by the government in their second consultation, which is the conforming principle, which is the pro rata principle. A week's holiday relates to the week that you usually work. Now, they don't address the issue of someone with no normal hours, because by the very phrase of falling into that paragraph, section 224, no normal hours, someone cannot pithily be said to say you usually work 3 days a week. The person with no normal hours or part-year worker is working many hours some weeks, but few or none other weeks. And what we say is clear is a week's holiday relates to the week that you usually work is no more and no different from stating that a week's leave is the average amount of work done in a week over the leave year for an irregular hours worker. It's the same. And you can see in the table that holiday entitlement for someone from the 1st of January 2009, it is actually from April 09, as it turned out, for 5.6 weeks of 3 days amounted to 16.8 days. Because that was effectively the week you usually work. But how do we do that for someone who works irregular or no normal hours? How do we get the week that they usually work, which is, we say, the clear aim of Regulation 13 expressly adopting Article 7 and Regulation 13A. Further, if I can then take you to the explanatory memorandum.
So that was a rhetorical question. How do we get to the week they usually work? So what is your answer to that then?
That effectively, the outcome of the answer is, at the end of the year, you know, although as Lady Arden said, you can constantly calculate that accrual by taking 12.07% of hours. So in week 51, to ensure that the person has the appropriate leave they should have had, in week 50 or 51, you can look back and see the leave that's been accrued in hours and whether it's been taken under 12.07%. And because 12.07% gives you an entitlement in hours, you can ensure that in week 52 or 51 or 52 that the remaining leave is taken before the end of the year. So it comes down to a simple analysis of the 12.07%, doing exactly what the ACAS guidance has done for many years.
And would this apply just as much to somebody who worked very irregular hours for 52 weeks of the year?
Yes, my lady, yes.
So the fact that she doesn't work during the school holidays is not really relevant to the calculation, other than it just reduces still more the number of hours she's actually worked over the year.
It has a lesser outcome. Our submissions are based on two methods, two primary methods in our case. Method one, which is to, as the tribunal did, is prorate the amount of weeks that the claimant worked in the year. Or method two, which is what I've spent most of my submissions on, which is the 12.07%. But the outcomes should marry up. So what you see, and can I just show you what the tribunal did, just to be immediately responsive to Lady Rose. If I can take you, please, to page 263. Page 263. And this is what we call our method one of our primary case in reference to the... And this was the tribunal, in its considered our secondary case. If the tribunal was wrong in its above conclusion and accepts the respondent's secondary case that entitlement to 5.6 weeks is prorated, and because the tribunal had found that the claimant only had an obligation to work during the term, it prorated the leave entitlement in accordance with the conformity principle on which we made submissions as follows. And the terms of the schools varied between 32 and 35 weeks. So method one, which we advocate, is that this method of prorating can be used. So if someone works or has an obligation to work 32 weeks, you look at 0.69 of 46.4. So 0.69, 32 weeks is 0.69, so 0.69 times 5.6 leads you to a total entitlement to 3.86. That's method one. Method two is you simply, as Milady Rose proposed, is that you apply the 12.07%, and whether or not the claimant works or not is merely adventitious. What matters is you're rewarding the hours worked with an entitlement to leave, proportionate to her working time.
But supposing then that she works every week of the year, but very irregular hours and not that many hours per week, and she says in the summer, I want to go away on holiday now abroad for 2.5 weeks, and I do that, how do you know whether she can do that, or is that all her annual leave, or is it not?
We know we can do it because, let's say by this stage she's working very irregularly, then she says I want to go away on holiday for a period of time, 2.5 weeks. We look at the number of days she's worked. Just take an instance of a number of days she's worked, let's say 100 days, and she's totaled what, 1,000 hours? 1,000, or it may be wrong, but 1,000 hours by that stage over 100 days. We know we divide 1,000 by 100, and we get each day of work is 10 hours long. And we know she's entitled to 12.07% in terms of, we know that she's entitled to 12.07% of the hours. She's worked 1,000 hours, so she's entitled to 120.7 hours. She's entitled to 120.7 hours of leave. And so that one can grant up to that amount of time.
What does that mean?
Well, that means in that case, if each working day is 10 hours, that's 12 days of leave. Because we've calculated if she's working at that rate.
So what do you mean by 12 days of leave? Does that mean that she can only go away for a week and a half abroad?
Well, 12 days, 12 days of leave, we know it would amount to, I'd have to do another calculation. I'm sorry, all these calculations set out in the...
Yes, but I'm just trying, I mean, the point of this is that people should be able to go away and not have to go into work for 5.6 weeks of the year.
Lady, yes.
So, leaving aside the fact that she actually doesn't go into work for the school holidays, as you've agreed that's relevant, so assuming someone's working not that many hours per week, but 52 weeks of the year.
Yes.
under your calculations, can they still actually leave the country without breaching their contract of employment for 5.6 weeks during the course of that year?
The equivalent of 5.6 weeks, which has accrued depending on their working entitlement.
Well, that's so the answer to my question is no. They can only go abroad for 1.5 weeks, and the other 50 weeks they have to turn up to school or work or whatever it is.
We say that's not the case, because if say but taking the example that you've used, if one's working 4 days a week irregularly through the, if one's working, milady, if one's working 4 hours a week irregularly through the year, but it ultimately ends up four hours a week, then each week of leave is the equivalent of 4 hours. So someone can go away for 5.6 weeks of work, but they are only paid at the rate of 4 hours for the week.
Yes, but isn't that what happens now under the legislation?
No, it isn't, because what one does is one just takes a shorter period. One takes a shorter period. One doesn't adjust the working time. One doesn't adjust, I beg your pardon, the working time to the period worked all over the year. We're looking, at the moment, my lady, your examples are based on someone working a settled pattern.
No, not necessarily. They're just somebody working for 52 weeks of the year, the random hours. 1 week it may be 6 hours, 1 week it may be 2 hours on different days, depending on who wants yoga lessons that week or whatever. What I'm trying to find out is whether, on the basis of your calculation, that person still has 5.6 weeks in the year when they do not have to come into work on any day or work any hour, or whether they only have a much shorter period during the year when they can actually be away from work.
Well, we say that if someone's working very few hours, they have the same right to be away, but each week of leave represents only a few hours of their pay.
Yes.
So
that's how the system works that the respondents are putting.
No, it doesn't, because the pay that one goes away for corresponds to 5.6 weeks of work. The current system doesn't correspond to 5.6 weeks of work, because the method of someone working irregular hours, someone who's going up and down, they may adventitiously get more or less. What we do is we apply the conformity principle to ensure that leave always corresponds to always corresponds to work, because the purpose of paid leave is leave from work. And when Regulation 13 transposes the 4 weeks entitlement, it's transposing the same entitlement as it did for Mr. Hine. If you only work for half the year, you only get half the year off. And simply it's building the entitlement into that. If you work throughout the year, you may end up with 4. If Mr. Hine worked throughout the year, but irregularly and on different hours, he will still get 4 weeks of leave, but each week of leave will accord to the average working hours over the year. And that's what our system does, and it enables, on the 12.07%, always to calculate the entitlement of a worker in terms of days. And what my learned friends and the Court of Appeals analysis does is it doesn't give you any way to calculate days for an irregular hours worker. There's no way to calculate days for an irregular hours worker who chooses then to take a day off.
Yeah, I'm slightly surprised that you answered my lady's question by saying, well, you still get 5.6 weeks, but you don't get all of that paid. And there's nothing in the directive or the regulations to say that if using the conformity principle, 5.6 weeks actually means only 2 weeks, using weeks in the way in which we would ordinarily use it when having a discussion about time. But you nonetheless get 3.6 on top unpaid.
No, I'm sorry, I misanswered, and I beg your pardon.
Can I just I thought your whole case is based on the calculation of time, not on a special interpretation of the calculation of the rate.
My Lord Briggs,
Rate
you're
of
right.
pay.
You're
Yeah,
right.
thank you.
That is right.
You're right. I'm sorry, I misspoke, and apologies for interrupting. You're right, that what it is one's using an accrual, as my Lord Burrows might have said, an accrual purpose to the amount of work that's done, and that dictates, because the whole purpose of leave is leave from work, that dictates the amount of leave, the entitlement to leave. And entitlement to leave can mean different things across.
So a week's leave may only mean a day's leave. Because if you only work 1 day a week's leave means a day.
Well, a week's leave only means 1 day when you're not working when you would have been working if you'd not been on holiday.
Yeah.
Yes.
Yes, it could, and exactly. For a part-time worker working 1 day a week, and the problem is all the examples used again and again and again have always been of full-time, regular pattern hours workers, leaving the court with this particular problem. And we say the conformity principle solves it for irregular hours working, and a statement of the conformity principle finds expression in the ACAS guidance.
Yes. I mean, the problems, it strikes me, might lie in the worker who works every day, but only a very small number of hours each day. So let's suppose they work 2 hours a day, and they have to come into work every day to work those 2 hours, then they won't get, by adding together their paid leave entitlement and the days when they're not working, because there are no days when they're not working, anything other than an extremely short, small number of days when they don't have to come into the office.
No, their entitlement, if they work throughout the year, the entitlement they work throughout the year will still be 5. On the example posed by you, they work 46.4 weeks of the year, but they work, 2 hours a week? Let's say 10 minutes a day or something like that.
2 hours a day.
2 hours a day. So that's 10 hours a week. And that means the conformity principle that they would take 5.6 weeks of leave. Their entitlement in each week of leave is to 10 hours leave.
Yes.
Just like the 1 day worker who works across the year, they can take 5.6 weeks. Their entitlement to leave is 1 day, is effectively 1 day. But what we've done with this, and if I can, and I'm not...
So you're saying that the person in Lord Briggs's example would be able to go on holiday abroad for 5.6 weeks, but during that time, actually, the only annual leave they're taking, if you look at what they would have worked otherwise, is the 2 hours a day.
Yes.
Right, and they only get paid for the 2 hours a day.
Yes, and that's right, because it conforms to the entitlement.
Yes, but isn't that the system that currently applies?
We say it isn't, and it isn't because what both examples that you've used fall into the same trap, if I may say, with a great deal of respect, with, for instance, the consultation, is you've both chosen examples of constant working hours, whereas we're talking about someone working chaotic hours.
Yeah.
So can I just give you the example? Someone works in the first 26 weeks for a day, an hour a week. They then take, at the end of those 26 weeks, they then say, right, I'm going to take 7 hours of leave, which is equivalent to 7 weeks. I'm going to take those, they come back to work and they start working furiously. So that by the second half of the year, they've accumulated now, hundreds and hundreds of hours. At this point, using the current Court of Appeal analysis, you're exhausted. You've had your 5.6 weeks of leave. Milady, I can see you frowning, but you have, because you've had 5.6 weeks at 1 hour a week. You've exhausted it. You've taken your 5.6 weeks of leave, and although you've worked furiously for the rest of the year, according to the Court of Appeal analysis, you get nothing more. So you must have a system, as the conformity principle does, to relate the irregularity to the fact the worker has increased a huge number of hours, to recognise that. Or take the example, again, not an uncommon example, of someone who's working full-time, doesn't take any leave, working full-time 5 days a week, and then they decide to reduce their work to 1 day a week. At the end of under the current examples, a few weeks passes, let's say 24 weeks passes, and they say, right, I want to take my 5.6 weeks of work. Under the Court of Appeal's current analysis, all you get is 5.6 weeks at 1 day a week. That's all you get. Takes in no account, because it's outside the reference period, of the full-time period of work under the Court of Appeal's analysis. But what the conformity principle does, the Greenfield principle, requiring recalculations as you go through the year, it requires to understand that leave for irregular working hours, not constant working hours, is a dynamic, evolving principle throughout the year that needs to be looked at. The entitlement to leave conforms to the working pattern. So I would caution the court with respect to using examples which are constant or consistent, as you both have posed to me. And where you look at the proper irregular hours person, and I've given two paradigm examples, the Court of Appeals analysis has no answer. Or taking the other example, let's say the worker who works full-time and then reduces to part-time. What is it? So 26 weeks at full-time doing 5 days, or a 5-day worker, then 20 weeks at 1 day a week. What is a day's leave? What is a day's leave under the Court of Appeal analysis? You don't have an answer. You can only calculate those irregular working patterns in some kind of weeks answer. But that's not the real world. The real world is people take leave in days, 2 days, or as my Lady Rose said, a number of days. And the only way you can get an answer is by using the conforming interpretation, looking at the pattern of work, 12.07% is what it burns out at being, and that gives you the answer. Otherwise, you're left in a position where you have a non-compliant right. You have those falling below the right adventitiously, depending on their working pattern, and those falling above the right, like Mrs. Brazel does. My Lords,
I must have misunderstood the Court of Appeal's judgment. I thought the Court of Appeals said that 5.6 weeks just means 5.6 weeks. In other words, Monday to Friday in 5 weeks and 0.6 of a week. Not obviously including weekends, but including bank holidays. That's why it's 5.6 and not 4. You could have, under the Court of Appeals analysis, regardless of your working pattern, that much leave. But maybe I've misunderstood it.
But it can only be calculated in weeks. There's no way to interpolate. And I'll show you.
What can only be calculated in weeks?
Leave. Under the Court of Appeals analysis, there's no way to interpolate weeks into days of leave. And can I show you what the current government guidance is, and just show you the way in which the calculation is suggested? And my lady, can I take you please to page 964? You see at page 964, this is government guidance that starts at page 959, and it's government guidance that came out after the Court of Appeals analysis, Court of Appeals decision, I beg your pardon, in Harpur Trust. And at the bottom of page 964, individuals who do not have guaranteed hours or do not have a regular working pattern, as there is no fixed work pattern on which to base annual leave, the entitlement should instead generally be kept in weeks. For workers who do not have regular hours or who are on an annualised hours contract, it may be appropriate to grant paid annual leave to be taken during periods when no work is performed. This depends on particular circumstances, and employers must ensure workers are able to take their full leave entitlement. This may also include workers on casual employment contracts. And if you go forward, please, to page 968. Casual, irregular or annualised hours. Workers who are in employment for a full leave year are entitled to 5.6 weeks annual leave. The working time regulations do not set out how to convert this into entitlement in days or hours for workers with irregular hours. Yeah, and I'm going to. In practice, if needed, employers may wish to calculate average days or hours worked each week based on a representative reference period, although the regulations do not expressly provide for this. In all cases, employers must ensure that each worker receives at least 5.6 weeks annual leave per year. And the problem, or one of the problems that the conforming principle seeks to address, is the way to convert an entitlement of an irregular hours worker into days or hours. And that's done by the ACAS method. And if you don't have that method, then one doesn't know what a day is, and under Regulation 13A(3), you know that the maximum entitlement is to 28 days of leave. If you can't calculate the day, even for an irregular hours worker, as the government guidance concedes, then you can't calculate the maximum.
But why do you need to calculate? Why, apart from the fact that you have to pay them, do you have to work out how many hours of the week that they're not coming into work are actually hours that they would otherwise have worked, or are hours that they wouldn't have worked even if they weren't taking annual leave? The only reason why you have to make that calculation is to decide how much to pay them, isn't it, for that week when they're not there?
Well, it goes to entitlement as well, my lady. If you remember the ACAS guidance, that unless people ask for leave in amount of a day or 2 days, that's the real world. And under the ACAS guidance, what you have is an ability to calculate the actual entitlement to leave. And so at page 284, you can see you can calculate the 72.6 minutes of paid holiday to which the person accrues. And we say that's why you need to be able to calculate this entitlement and in order to be able to grant it. Otherwise, with irregular hours workers, such as Mrs. Brazel, one can't grant them the amount of time. And it's right, of course, I should have said that there's no question here that Mrs. Brazel always got the full entitlement to leave. She had the school holidays where she wasn't working, so there's no question here. But it's right, we say this is the only method that gives you an accurate way to calculate entitlement. And what we say, what the intervener and the claimant are wrong in stating is that Working Time Directive has ended up giving more favourable treatment, as the Court of Appeal said, and the Court of Appeal was wrong to say that the Working Time Regulations, I beg your pardon, have implemented a more favourable system than the Working Time Directive. And the reason why it isn't a more favourable system is because of the facts I set out of Greenfield and then the other facts. And I'd like to take you, please, Greenfield is a real case, which the Court of Appeals analysis does not answer. But so too is the case of Brandes. And in Brandes, if I can take you, please, to divider 15. Brandes was a case which was dealt with under reasoned order, so the court didn't feel the need to have a hearing on it. And if one goes over the page 851, sorry, 85, beg your pardon, it's 850 and page 851. The legal context was the Part-Time Workers Directive and Article 7 of the the legal context was the Part-Time Workers Directive and Article 7 of the Working Time Directive. And as you can see, it's the same German law that says that holiday pay shall be calculated in accordance with the average pay the employee received in the last 13 weeks prior to the start of the leave. And what happened with Mrs. Brandes is she was working full-time and she had accrued at paragraph 10. She then returned to work after maternity leave at paragraph 12 on the basis of 3 days per week. She'd accrued at paragraph 13 29 days of leave. At paragraph 15, it was said by her employer that Mrs. Brandes is entitled to remaining leave of 17 days, namely 29 days divided by 5 days multiplied by 3 days. So that would give her, under her new pattern of work, the same number of weeks off, but not the same number of days, because her pattern of work had changed. And Landers said, well, that's fine, you can have, let's say that's the 5 weeks or 5.6 weeks, you can have the same number of weeks off, no problem, we'll give you that. But if one goes forward, please, to page 855, paragraph 37, as for the argument put forward by Land, according to which the entitlement to paid annual leave previously accumulated by Mrs. Brandes would not suffer any reduction, since, expressed in terms of weeks of leave, it would remain identical before and after her move to part-time work, it is clear that the argument cannot be accepted, as both the referring court and the Commission have observed. Indeed, the fact that a part-time worker who normally works 3 full days per week is during a particular week absent from work does not in any way imply, contrary to what Land contends, that the worker would thus obtain the equivalent of 5 days of leave, which, having accumulated, then he would, when he worked full-time, must clearly be understood as 5 complete days during which the worker is relieved of being under the obligation to work in the absence of such leave. In having 1 week of leave recognised in the context of his now part-time work, represented by 3 full days of work per week, it's clear that the worker is being released from his obligation to work only to the extent of 3 full days. The equivalent argument of the German government, which moreover it had already put in according to this case in Land's Tyrols, according to which the national rule at issue in the main proceedings does not infringe European law on the ground that a worker who is no longer required to work every day of the week must be released from his obligations during a reduced period number of days in order to be able to benefit from a period of rest which is as long as previously, must also be rejected. Such an argument, and this is the key part, such an argument fails to distinguish the period of rest represented by taking a period of actual leave and normal professional inactivity. So that's normal professional inactivity within a period during which the worker is not deemed to work due to the employment relationship binding him with his employer. And we say Brandes is a key case showing that an approach based purely on weeks does not work and does not conform to Article 7, because, taking the example, putting Brandes into the UK laws as it existed at the time of Mrs. Brazel's case, Mrs. Brandes works full-time. After a period, she returns to 3 days per week. After 12 weeks back at work, at 3 days per week, she wants to take leave. At that point, her leave is only 5.6 weeks, if it's over the year, including the period she worked full-time. At that point, it's only 5.6 weeks over a reference period where her rate of pay was 3 days per week. What the conforming principle does is it takes into account her pattern of work at the full time, at the 5 days per week, and it effectively enhances that entitlement to leave in accordance with Article 7. So what it does, and the mechanism by which it does that, if I can show the court by taking you, please, to Regulation 13. You just give me a moment, please. We've taken you to Regulation 13, which is to be found at Regulation 16, page 587. A worker is entitled to be paid in respect of any period of annual leave to which he is entitled under Regulation 13 and 13A, at the rate of a week's pay in respect of each week of leave. And the conforming principle operates on the entitlement under Regulation 13 and 13A and as to what each week's leave. So, under Method 2, this worker has an entitlement to 5.6 weeks of annual leave. That's 5.6 working weeks. That's what each week of leave means. It's leave from a working week. A working week, as I've said, is the average amount of work in a week over the leave year. A worker is entitled to their normal pay for their working week on leave. Pay is calculated by section 224, as amended by regulation 16, and then that amount, that rate of pay, is applied to each week of leave to which the worker is entitled. In order to apply that rate of pay to each week of leave, it's necessary to apply that rate of pay at a correspondent to the average working week, because that's what each week of leave means. The correspondent for an hourly paid worker would be the number of hours in the average working week relative to the number of hours in the reference period. And let me demonstrate that by way of an example. Take, for example, a worker who has worked over the leave year at an average of 20 hours per week. So this irregular working worker has worked at an average of 20 hours per week. But during the 12-week reference period, the section 224 reference period, that worker has only worked for 10 hours per week. Under my learned friends in the Court of Appeals analysis, that worker would be paid 5.6 weeks of leave at 10 hours a week. However, they failed to take into account that the rate of pay is applied to each week of leave. And as each week of leave is for the average working week, which is 20 hours, that rate of pay has to be doubled for each week of pay. So the rate of pay by the reference period, when applied to in respect of each week of leave in Regulation 16, has to be doubled, because the reference period has 10 hours per week, but we know the average working week, the entitlement to leave per week, is 20 hours. That's how the analysis, the legal analysis works, but for an hourly paid worker, that shakes down to the easily understood 12.07% formula. But the longhand calculations can be made, and from the longhand calculations, which are set out in the annex, one can calculate, we say clearly, under this method, what the entitlement of a worker is to leave under this, our method 2. And the key is to understand that the entitlement of leave is under Regulation 13 and 13A, and that is applied then to each week of leave, which is the average working week. And that is no more and no less than applying the conformity, pro rata, or accrual principle. I'm conscious that I have a limited amount of time left, and I just want to make some brief submissions, if I may, in terms of addressing. I want to go back, so I hope I've concluded by showing, as it were, the two methods, method 1 and method 2, and I just want to. And I departed, as it were, from my submissions, which were on the working time regulations being transposed. I've made fully my submission that working time regulations were transposed expressly by way of Regulation 2.2 and 13 and 13A. I've made those submissions. But I just also want to submit that the conforming interpretation under leasing, and here my Lord Borough's apologies, it isn't my terminology, the conforming interpretation, but we say that one should be reading Regulation 13 and 13A in conformity with Regulation 13 you should be reading in conformity with Article 7, and I've made my submissions how Regulation 13A is clearly intended to apply the same result as Regulation 13. And it should be remembered, in the conforming interpretation, one is looking at the result to be achieved. Now, the result to be achieved under Article 7 is not that some workers should be treated more favourably. It is that every worker should have the floor of rights. And what my learned friends say is, well, Mrs. Brazel is treated more favourably as a result of the calculations under Regulation 16 and 13 and 13A, and therefore leasing has no place. We say that's wrong because we say we've shown if you apply the Court of Appeals analysis or my learned friend's interpretations to the Greenfield facts, if you apply them to the Brandes facts, their method would treat both Greenfield and Brandes less favourably. They would breach their Article 7 rights. Therefore, Marleasing does have a role to play. And not only does it have a role to play in the conforming interpretation of 13 and 13A, but that must, we say, be powerful, a powerful interpretive factor to look at the fact that when my learned friends say, well, this is a more favourable scheme, it's only a more favourable scheme on adventitious facts, on Mrs. Brazel's facts. On other facts, it isn't. I'm not asking you to look at hypotheticals. I'm showing you cases of Greenfield, of Brandes, where the current Court of Appeal analysis would lead to less favourable facts. And what you have, perhaps in answer to this from my learned friends, is a kind of pick and mix Marleasing. Don't worry, they say. We have, Mrs. Brazel is treated more favourably. You can't use Marleasing for her. But about Greenfield and Brandes, if they're less favourable, well, they'll be saved by Marleasing and applying that. We say that's an unsatisfactory and contrary to the clear meaning of Regulations 13 and 13A. And further, we also say that that this interpretive principle is bolstered in this case, where the courts have been prepared to assume an intention to give effect to domestic legislation. And can I take the court, please, to risk management, which is at page 778. Page 778. And risk management concerned the public contracts regulations, the compulsory tendering regulations. And what happened is Harrow awarded a contract for insurance to a mutual. Harrow Council awarded a contract to a mutual that it owned along with other London boroughs, and it controlled. And risk management challenged the award of that contract and said it fell within the Public Contracts Act. However, the European Court of Justice had provided an exemption called the Tekel exemption, which can be seen at page 788. And the exemption is in the second of the indented paragraphs, and it starts 4 lines down. The position can be otherwise, only in the case where the local authority exercises over the person concerned a control which is similar to that which it exercises over its own departments, and at the same time, that person carries out the essential parts of its activities with the controlling local authorities or authority. Now, it was common ground that that exemption was not to be found in the Working Time Directive. It was not to be found, I beg your pardon, in the Public Contracts Directive. It was common ground that that exemption was not to be found in the Public Contracts Directive. So similarly, perhaps, to Article 7 and the Working Time Regulations, the conforming interpretation, the pro rata accrual interpretation, is not to be found on the face of the directives. And what the Supreme Court held at paragraph 22, page 790, it is a sufficient answer as Mr. Assumption for Harrow submitted to say that the basis for implying the Tekel exemption into the 2006 regulations is to be found in the underlying purpose, which was to give effect to the directive. The absence of any reference to the exemption in the regulations is of no more significance than the absence of any reference to it in the directive that was being transposed. The exemption in favour of contracts which satisfy its conditions was read into the directive by the Court of Justice in Tekel because it was thought undesirable for contracts of that kind to be opened up for public procurement. This was not just a technicality, it was a considered policy of EU law. It would be odd if a significant and policy-based exemption were to apply in some member states and not others, especially as one of the aims of the directive was to harmonise procedures. This can be seen from recital 2 of the preamble to the directive, which states in part. Now here, the purpose of the Working Time Directive is to give leave. The whole premise of the Working Time Directive and what separates annual leave, paid annual leave from other leave, is its leave from work. Accordingly, or consequently, to use the words of the European Court of Justice, the entitlement to leave conforms to the working pattern. And if I can take you, please, over the page 791 to paragraph 25. As for the meaning and effect of the 2006 regulations, I think it would be wrong to apply a literal approach to the words and phrases used in it, such as in the definitions of public contract and public services contract. And actually, the public contracts regulations, unlike the working time regulations, use different language and transpose the language into English law.
Give me where you're reading.
Sorry, I beg your pardon. Page 791, paragraph 25. I beg your pardon.
25, thank you.
And at the top of page 792, a purposive approach should be adopted. As Lord Diplock indicated, this means regard must be had to the context in which the regulations were made, to their subject matter, to their purpose. Would it be inconsistent with the achievement of that purpose if the technical exemption were not to be held to apply to them? Was this an exemption to which Parliament must have intended them to be subject? Having regard to the background of EU law against which the regulations were made, the definitions in the regulations can be taken to express the same idea as those in the directive. Thus, something which amounts to a contract in domestic law can nevertheless be held without doing undue violence to the words of the regulations, not to be a relevant contract for the purpose of the public procurement rules. And we say it's all the more strong here, that same analysis, where you have in the working time regulations 4 weeks of annual leave, or 1.6 weeks, which correspond to annual leave of at least 4 weeks in the directive. And finally, in my submissions, just on the domestic interpretive principles. I've given the references for Benyon in my case, that one assumes the legislature is rational, reasonable and informed and pursues a clear purpose in a coherent and principled manner. And the conformity principle is that neutral principle. It treats all the same, whereas the Court of Appeal treats materially different situations, materially the same differently. Take, for example, this paradigm case of a worker who works 2.5 days every week of the year and then takes 5.6 weeks of leave. Their 5.6 weeks of leave are at an entitlement of 2.5 days, according to the Court of Appeal. Equally, if you took a worker who's working only 6 months of the year over 5 days, but works no other days in the year, so works for those 6 months at 5 days per week, according to the Court of Appeal's analysis, their leave is based at 5.6 weeks of 5 days' pay. It's double that of someone doing precisely the same amount of work in the year, whereas the conforming principle for someone working 6 months would conform to 2.8 weeks of work at 2.8 weeks of leave at effectively 5 days' pay. That's because the entitlement by working 6 months, the entitlement of working 6 months during the year is half, as it is in Hine, conforms to the pattern of work. So what the conformity principle does is treat materially the same circumstances the same as in that circumstance. What the Court of Appeal's analysis does is give adventitiously different results. And if I can also point to, again, we set out in our case, we say the Court of Appeal's analysis offends the principle against absurdity. And what you have with Mrs. Brazel is, because of her working pattern, it adventitiously favours her. But if one takes the case of, for instance, invigilators in school who might only work 2 or 3 weeks in a term, those who only teach a sport in one term of a year, but come back every year. Take the case of a recorder working 3 weeks a year. According to the Court of Appeal's analysis, the answer is simple. The recorder, the summer term worker, the invigilator are all entitled to 5.6 weeks of leave at their reference pay, which may be, in the case of the recorder, almost double. Holiday pay entitlement almost double to their working time. And those, we say, can't have been the intention of Parliament when they implemented the system. And so I haven't taken the court, nor do I have time to take the court to my third method, which is our secondary case. I rely principally on the first two methods, methods 1 and 2. And we say, and we urge the court to endorse effectively the conformity principle, the fact it's been transposed into UK law, and in our complex proofs in the annex.
Well, which of these are methods 1 and which are methods 2 then in your annex?
Method 1 is the prorating, milady. Method 2 is the entitlement to each week is the 12.07%.
But in your calculations annex, did you do each one on both methods?
We didn't. In the calculations annex, we did the method 1 on the infrequent worker. If one looks at the calculation, so we did method 1 on the infrequent worker, and then we did method 2 on the rest of the workers in the calculations annex. But if it would assist the court, we can certainly hand up a calculation on method 2, for instance, for the infrequent worker. And my Lord,
you say that. Sorry, I didn't mean to interrupt. You say that looked across the whole range, this is an unusual case, perhaps, where the worker is going to end up worse off on your calculation, but there are going to be lots of cases where the worker is going to end up better off on your calculations. And according to you, what you say, Europe requires through the conformity principle us to apply. Is it rather surprising then that we've got an intervener on Unison who is putting forward the case that we should reject your calculations, presumably on the basis that they regard this as unhelpful to workers generally?
Well, it affects term time. It prevents what effectively it means that for those working, say, between 32 and 35 weeks a year, if you apply the Court of Appeals analysis, holiday pay works out at 17.05%, roughly speaking. If you apply the conforming analysis, holiday pay works out equally for everyone, neutrally for everyone at 12.07%.
But I think you're saying that the Court of Appeals analysis also produces less than 12.07% for certain patterns of work.
Yes, for Brandes and or for Greenfield,
yes.
Precisely. So what we say, the 12.07%, our submission to conformity principle, is entirely neutral. And it's no part of Harpur Trust's position is that it should be a neutral calculation, everyone benefiting equally. It doesn't want to, nor should it, disbenefit some. My Lord, I'm sorry, I'm conscious I've gone a bit over my time.
You did lose 5 minutes.
Well, I'm grateful, in which case I'm going to just simply reserve the rest of my time for reply. My Lord, unless I can be of any further assistance, those are my submissions, and we say this appeal should be dismissed.
Thank you very much. Mr. Gallagher.
Lords and ladies, as you heard from my learned friend Mr. Glynn, I appear with Mr. Wilson, who unfortunately can't be here today. I would like simply to say that his contribution, as you've seen, no doubt, from the decisions below to this case, has been very considerable indeed. And of course, I appear with Miss Webber. I'm grateful to the court for having dealt with the revised time request last week, and learned friend Mr. Ford and I proposed to divide our time and oral argument between us on the various topics. I propose to deal with the circumstances of Mrs. Brazel's case and the circumstances of some other types of worker the appellant's proposed scheme would apply to. Also, the scheme of the working time regulations, including the provisions in Regulations 13 and 13A and other parts of the regulations, and Section 229 of the Employment Rights Act, and the approach to construction in principle, including the points raised by learned friend Mr. Glynn regarding European law, the limits applicability of MAR leasing, and the risk management partners TECAL case. Learned from Mr. Ford will deal with the background to the making of the working time regulations, the consultation exercises and reports, the European Court of Justice case law, and the difficulties with the appellant's proposed scheme. Lords and ladies, the working time regulations are in our submission a statutory scheme which is clear and which extends to the whole of Great Britain, designed to be operated by many millions of employers and millions of workers. They're universal rules. The essence of Mrs. Brazel's claim is, and always has been, simple. She should have been compensated for her 5.6 weeks, that is 4 weeks in Regulation 13 and 1.6 weeks in Regulation 13A, statutory paid holiday each year by applying Section 224 of the Employment Rights Act, the rate of a week's pay for those 5.6 weeks. In fact, the appellant, her employer, was not compensating Mrs. Brazel for her holiday in this way. It calculated Mrs. Brazel's holiday pay as being 12.07% of actual earnings at the end of each term. This approach did not compensate for the full 5.6 weeks of holiday each year, and the respondent claims it's entitled not to do so because of being able to prorate, to use the very general term. And what's ensued then from the Employment Tribunal to this court is a series of shifting arguments as to why the appellant is entitled to reduce Mrs. Brazel's paid holiday entitlement from the level set out in these clearly expressed statutory provisions. And the appellant's arguments on this appeal are, for the reasons we and the intervener have set out in our written submissions, and which Mr. Ford and I will develop orally, contrary to the way in which this clear statutory scheme operates on its face, and are not justified by any legitimate method of statutory interpretation, including resort to mar leasing or the approach in risk management partners. The appellant also proposes a system which is both unclear and unworkable, as the many difficulties we and the intervener have set out in writing, which will be dealt with in submissions, demonstrate. So we submit, Lords and Ladies, that the Court of Appeal and the Employment Appeal Tribunal were right in this case, and nothing that's fallen from my learned friend this morning should cause you to reach a different result. This Court should not accede to what is in form and in substance, we submit, a request to completely rewrite this clear statutory scheme in this way. Lords and Ladies, can I turn now to the facts of Mrs. Brazel's case and also touch on the circumstances of some other workers? As you've seen from the decision of the Employment Tribunal, Mrs. Brazel was employed with continuous employment since 2002 on a permanent 0 hours contract. So she was employed throughout the relevant leave years in respect of which these claims were made to the Employment Tribunal. She did not actually perform work on 46.4 weeks of the year, that being, of course, 52 weeks minus the 5.6 weeks statutory holiday entitlement of the working time regulations. But that is not unusual. She is nonetheless on a permanent contract. She's employed throughout, a point that Lord Justice Underhill regarded as being of some importance in the context of this case in his judgment. Can I take you, and I appreciate it's now very near the short adjournment, but can I take you briefly, if I may, to the contractual material, which Mr. Glynn took you to, but I'd like to take you to again. Mrs. Brazel's contract is at page 267 in the core volume. And you see on page 268 the provisions just below appointment and duration as to appointment and as to continuity of employment, which I've referred to. Turning over the page, you see under clause 11, duties include but not limited to providing individual personal tuition in your subject or instrument. And in addition, you're required to carry out all duties of a visiting music teacher as reasonably directed by the Director of Music, and the duties are set out in the schedule. Clause 12 is an utmost endeavours clause promoting the interest and reputation of the employer. Clause 17 on working hours. As you've seen, there were no normal working hours and no minimum hours of work. Clause 18, other employment, that Mrs. Brazel was not entitled to accept other employment except in certain circumstances. Clause 19, private arrangements. Clause 20, a post-termination restriction. Turning over the page, you see at, I should say at the bottom of the page, Mr. Glynn referred to it, it was in the Employment Tribunal's judgment, the rate of pay is set out in the remuneration section, bottom 270. Turning over to 271, the holiday entitlement. Clause 27, the holiday year is defined, the 5.6 weeks holiday is set out, and then the statement that holiday must be taken during the normal school holidays or at such times convenient for the school. And at 28, unused holiday entitlement cannot be carried forward to a subsequent holiday year. The duties of the music teacher, which are referred to in the main part of the contract, are set out at page 275. I won't go through them all, but they are a variety of duties, starting with tuition, but also other duties in relation to other matters as well. To say, Lords and Ladies, as the appellant does, that the result reached in Mrs. Brazel's case in relation to the application of the statutory holiday entitlement by the Employment Appeals Tribunal and the Court of Appeal is adventitious, capricious, or, as was set out in writing, the result of a lottery, the appellant's case, is to overlook what we refer to in our case at paragraphs 95 and 96, for your note, page 161, as these complex interactions and work-wage bargains and the overall balance of benefits and disadvantages inherent in such a contract. Lords and Ladies, as Lord Justice Underhill observed in paragraph 70 of his judgment, there is nothing unreasonable in our submission in treating employment on a permanent contract of this sort as a sufficient basis for fixing the quantum of holiday entitlement, irrespective of the precise amount of work performed. Mrs. Brazel does not ask for a lottery win, she asks for her statutory entitlement properly calculated. And also in evidence before the Employment Tribunal and referred to in the judgment, I appreciate the clock has ticked past 1 o'clock in the room, although it might...
The clock is marginally fast. You've got 2 minutes.
2 minutes. Well, can I take you to these other contracts? It may be that I make my submission on them after the short adjournment. Also in evidence before the Employment Tribunal and referred to in its judgment and reasons were the contracts of some of the other workers at the school. They were cited as comparators in the part-time workers claim, which is not material for present purposes. But what is material is the contractual provisions in those contracts, because they illustrate in our submission the sheer scale of what the appellant is asking this court to do. Can you turn to the contract, please, of the salaried music teacher, which is at page 2246. I'm so sorry, the contract starts at 2244. You see at 2244, that's the contract of employment of a teacher, in fact a salaried teacher. If you turn over to 2246, there are a number of similar provisions in this agreement, as with Mrs. Brazel's written contract. Clause 7, responsibilities and duties are set out in the job specification. 7.2 on all duties reasonably required. 7.3, similar point about not undertaking other duties. Section 8, the minimum holiday entitlement is set out. Turning over to 2247, here it says during school holidays you will not be required to perform any duties other than those normally performed by a teacher during such holidays or as reasonably required by the head. Very similar to the provision I took you to in Mrs. Brazel's contract. Paragraph 8.5, termination of employment during the academic year will be will give rise to an entitlement in lieu of accrued but untaken holiday under the Working Time Regulations 1998. That, of course, begs the question, what holiday, if a teacher in these circumstances leaves during the academic year? Because, Lords and Ladies, and this is the point I'll finish on, I think, given the time, these are not full-year contracts either, in the sense of contracts which require work on 46.4 weeks of the year. there will clearly be periods when the salaried full-time music teacher, as they're described, is not working in the school holidays, and so has weeks which do not count towards the working time regulation holiday entitlement. Now, learned friend opened his submissions this morning by saying this case was about workers who work variable hours. But in fact, the contract of employment of this salaried teacher, the duties to be performed during the weeks of the year, and the times at which those duties are to be performed are very similar indeed to Mrs. Brazel's contract. So too with the 0.24 full-time equivalent salaried teacher's contract, which is at EF2256.
Presumably the salaried teacher just gets a monthly salary.
They do, lady,
and
yes.
they get that during July and August and September as well. They don't stop getting their monthly salaries during the... Yes, so, but that's different from Ms. Brazel's.
Well, indeed, lady, yes, but they both have the same sets of rights under the working time regulations, and crucially, Regulation 14, which is the provision reflected in Clause 8.5 of the contract, will need to be applied in order to determine whether there is any outstanding accrued holiday entitlement on termination. So the entitlements in the working time regulations and the various provisions I'll take you to after the short adjournment must be applied in the same way to this salaried teacher as they are to Mrs. Brazel. And actually what the appellant is asking you to do is not simply to change the position for Mrs. Brazel, a 0 hours contract worker, but also to interpret these regulations in such a way that they would affect other workers, such as the salaried teacher, who work for fewer than 46.4 weeks of the year. And that is a very, very wide argument and submission with very wide consequences, which I, Mr. Ford, will return to after the short adjournment, if we may.
Well, the court will now adjourn and resume at 2 o'clock. Thank you very much.